Okay, looks like we have both sides here. Mr. Siegel, you are for the appellant. Do you wish to reserve any time?
Yes, Your Honor, 5 minutes, please.
You got it. Go ahead, sir.
Thank you, Your Honor. May it please the court, Lee Siegel representing appellant Christopher Chesney. This appeal comes down to a simple question. And the question is must a foreclosing plaintiff comply with a condition precedent? And is their compliance excused simply by the fact that this is a second time that they're attempting to foreclose on the same note and mortgage? And we believe the answer to that question is no.
Let me ask you, what is the condition precedent?
The conditions precedent is defined in paragraph 22 of the mortgage, Your Honor.
Does that say anything about the notice address, paragraph 22?
No, paragraph 15 addresses the
paragraph 15. So let me posit something to you. Paragraph 15 is a deemer clause. Paragraph 15, and when I say a deemer clause, meaning you get a presumption of notice if you can prove that it was sent to the notice address. But the notice to the notice address is not the condition precedent. The condition precedent is notice. So if a bank, if a plaintiff, a foreclosure plaintiff fails to prove that it was sent pursuant to 15 to the notice address, well, in other words, if they don't get the presumption if they can't prove it was mailed to the notice address, but does that mean does that per se mean that the condition precedent wasn't met?
Yes, Your Honor, because the reading of the paragraph in its plain language, and this is drafted by the
Which paragraph?
Lender, paragraph 22, it's that lender must give notice.
Okay, so it must give notice. Right? What if the bank president went to the person's house and said, "Hey, you're in default. I got something for you. Here's how to cure if you want to." But that wasn't the notice address. He was at the homeowner's other house. Would that condition precedent have failed because he didn't send something to the notice address?
Well, no, there is a by any other means section of paragraph 15. If the court looks at paragraph 15, it's in the record at page 150.
So the notice address only has to do with the presumption of notice if the bank can establish that it was sent to the notice address, right?
Well, the notice section says that all notices given by a borrower to lender must be in writing. Any notice to borrower in connection with the security instrument shall be deemed to have been given to borrower when mailed by first-class mail or when actually delivered to borrower's notice address if sent by any other
It'll
means.
be deemed, in other words, you don't have to prove anything more. That's all you got to do. And it's like a rebuttable presumption, I guess. I don't know if it's rebuttable. That's not important. So my point is, but you concede that notice could be provided some other way, right? And the condition, if this was provided effectively some other way, would the condition precedent have been met?
Notice can be provided by other means according to paragraph 15, yes. But paragraph 22 states that prior to acceleration, lender shall give notice to borrower following a breach of the covenant, and the notice has to specify certain things. So if the bank president comes over to the borrower's other address and says, "Hey, I got bad news for you, you're in default of your mortgage," that wouldn't constitute sufficient notice because it doesn't apply.
What if he had it in the requisite writing?
Well, it would depend on the content of the writing at that point, because
let's assume that the content of the writing is satisfactory.
Then yes, I think that would satisfy.
So why isn't the prior notice good here then? Why isn't the actual prior notice? You just talked about the fact that they were on notice before because it's the second foreclosure action. Why isn't it sufficient then?
Because the prior case was dismissed with prejudice. So the defense case consisted of the court taking judicial notice of the order of dismissal of the prior case. The order of dismissal of the prior case was an order of involuntary dismissal. It's in the record at page 818, I believe, and 811. I'm sorry, and it's an order granting involuntary dismissal. And under the rules, a dismissal under 1.420B, which is involuntary, is with prejudice unless otherwise noted. The order reads, defendant's motion for involuntary dismissal at the close of evidence is hereby granted. So there's no qualification or otherwise advising the parties that it's without prejudice. Therefore, it's with prejudice. When the case is dismissed with prejudice, that's an adjudication on the merits on that default date, and the plaintiff attempted to cure that by moving the default date in the next complaint 5 years. So they changed their default date to 2014, but then they have the duty of notifying the defendant of what the new default that they're going to hold him accountable for is and what he can do to cure it. And without any evidence that that was sent to the proper notice address, then their case fails. The case that's directly on point with this issue is the Blum case, which is cited in our brief. Blum is a very short case. It just says when a plaintiff doesn't send the notice to the notice address, the case needs to be involuntarily dismissed. And the judge in entering
Mr.
the order.
Siegel, I
Yes.
have two questions for you. Your opponent makes the argument that the condition proceeding was substantially complied with and that your client wasn't prejudiced, both of which are required in that analysis. And she also makes an argument based on a case from this court that your dismissal argument doesn't hold water because your client never tried to cure his dismissal, and she's relying on the Green Tree Milam case. So could you please address both of those points?
Certainly, Your Honor. So as to the first point, the word prejudice comes up in the transcript twice, and it's both times during citations to the Bartram Supreme Court case. The word prejudice is never mentioned once by plaintiff's counsel or myself, except for when citing to the Bartram case. The court injects the prejudice element in writing an order that explains why he's granting the final judgment, but that was never argued by the plaintiff, and therefore that's waived because they had the defendant there. They could have asked him a multitude of questions regarding any prejudice that he might have had, and the borrower is not under a burden to prove prejudice until the plaintiff proves that they complied with the condition precedent. And substantial compliance analysis applies to the contents of the letter.
I'm sorry, Mr. Siegel. I know you were in the process of answering Judge LeBrit's question, but you lost me in answering that. Can you walk me through how you're getting, who has to prove what and where and when? Because it seems to me that my understanding of conditions precedent, that the specific denial that has to be made is incumbent upon your client as the defendant. Your client has to prove if they are able to show that the denial of the condition precedent, I would think traditionally would be in the nature of an affirmative defense and avoidance, wouldn't it? Which would be incumbent upon your client to prove.
Yes, Your Honor, and that and in the record at page 101 through 104 is the amended answer and affirmative defenses. And the condition precedent is both specifically denied and raises an affirmative defense. So in response to paragraph 8, I believe, which is where they allege that all conditions precedent have been complied with or occurred, the response in the amended answer is defendant specifically denies the occurrence or performance of any condition.
Right, that's the pleading. Now, as far as to who has to prove what, that was what you were talking about, and that's what my concern is who exactly who are you contending has to prove the failure of a condition precedent? Who has to prove prejudice or lack thereof? Who bears that initial burden? And what case law are you reciting, or in order to support that, whatever your understanding is?
Well, I think it's a combined pleading proof issue. So once the defendant,
no, proof is separate from pleading.
right?
But so pleading is one thing. Plaintiffs are allowed to plead generally the conditions precedent have been complied with. If you wish to put that in dispute, it is incumbent upon you in the Florida Rules of Civil Procedure to plead it specifically. That's to get the issue in play. My question is, all right, it's in play. The issue is in play. Let's assume that for this. Who has to prove compliance with conditions precedent? Or conversely has to prove the lack of condition precedent being complied with, and who then would have to prove prejudice? How does that play out in the trial?
So as I was saying, after a specific denial is made, the burden shifts back to the plaintiff to prove that the condition precedent was complied with.
Okay.
And so that's their burden at trial. In the trial, what they did was they came forward with 2 letters that are addressed, one to the property address and one to a PO box. Neither one has any ties to the mailing address that's listed specifically on the mortgage. And so they failed to prove that the condition precedent was complied with at all, because again, substantial compliance would only apply to the contents. So until and unless you mail the letter to the proper mailing address, which is the notice address, you haven't complied. At that
So
point,
your failure of proof argument then necessarily ties into the notion that substantial compliance only applies and is limited to contents of letter, not address of letter.
right, I don't think you can substantially comply by mailing the letter to a wrong address. I don't think you can say, well,
Okay.
we got it close. We mailed it to 123
Whether
Elm
you got
Street.
it there
as opposed
is
to
a
124
binary
Elm Street.
issue. Whether it arrived, whether it was received by the party who received notice is a binary issue, yes or no. So if we get beyond that and say that you can't substantially comply with whether the notice was received, because there's no gradations there, why wouldn't they have met that burden requiring a shift to go to what Judge Lucas is asking about whose burden when, if they said, well, we sent it to the property address?
Because that's not the notice address.
So that, what's that?
Because that's not the notice address in this case. It's
Right, but-
ordinarily, it
but-
is the notice address.
Just assume I'm right, and I'm which is not always the case, and that paragraph 15 is not a condition precedent. That's just a deemer clause which says if you can prove going to the notice address, it's deemed to have arrived effectively, and say, and assume I'm right. Again, I'm not always right. That the only condition precedent is just notice. So, and they said, well, we sent it to the property address. So it doesn't the burden shift to you and say, well, no, we didn't get it because it was rented out. We didn't live there. The renters threw it in the circular file.
That would put the receipt at issue, and the receipt is simply not a requirement of the plaintiff to prove. So saying they sent it, if they sent it to the North Pole, that wouldn't comply with a condition precedent, because you have to send it to a proper address. You can't just say we sent it wherever we felt like sending it and we complied because we sent it. The act of the sending is not the completion of the condition. The sending it to an address where it will be received by the borrower is the compliance with the condition precedent. You can't say, well, we drafted 10 letters, we sent them out to 10 different addresses in 10 different states. We substantially complied. Maybe none of them was the right address, but hey, the letters went out and that's all we have to show. You have to show that you sent it to the address that you agreed to contractually with the borrower to send it to.
What about the fact that the record, there's an affidavit of a process server that establishes that the PO box address that the notice was mailed to was listed on multiple different public records for Mr. Cheney, and that was in this record. It was the affidavit of diligent search. Does that change anything?
No, Your Honor, because the affidavit of diligent search wasn't evidence. It might be in the record because the plaintiff filed it to support maybe a publication, but that wasn't entered into evidence at the trial, wasn't argued at the trial by the plaintiff to make reference to it and say, well, it's in the record, therefore it means something. Just because it's in the record doesn't mean it means something. It wasn't presented by the plaintiff at the trial to say, hey, Judge, look, you can tell this was the right address because it's in the affidavit of diligent search. They never did that. They never entered into evidence.
Mr. Siegel, your notion of what constitutes prejudice and how it plays out does not seem to align with how the fourth DCA viewed it in Caraccio. Would you agree?
Yes, I agree. I don't think the prejudice analysis done by the fourth DCA is
correct. You want us, yeah, you want us to, you would have us conflict with our sister district on this point.
Well, I don't think this court has ever ruled specifically on the prejudice issue. I think prejudice has been twisted around by the courts in the foreclosure context, where if we look at where it came from, which was the insurance context, the prejudice is on the insurer to show that they're prejudiced by the homeowner not notifying them of a loss. And so it's kind of been flipped around to say now it's the borrower who didn't write the contract, who didn't get a chance to edit the contract anyway, and signs the contract as is. It's now his burden to show that he's prejudiced by the fact that the financial institution whose burden it is to send the letter and they didn't do it, he has to show that he's prejudiced by the fact they didn't do it. I think that's turning the prejudice argument on its head, sort of, because again, the borrower is not the one that has to comply with the condition precedent. The financial institution does, and until and unless they do, I don't think there's any burden on the borrower to show prejudice or lack thereof, because they first have to comply. The court can't rewrite the contract. If the contract requires that they send a notice to the proper address, and again, sending it to 10 addresses, including the property address, as long as none of those were the right address, doesn't get you there. This contract, this specific mortgage, has a property address and a mailing address listed on it. So it's clear where Mr. Chesney was expecting to receive notices. And there's zero evidence in the record that they sent the notice to the proper address. The
Siegel, you're coming in your 5 minutes, just to let you know.
Oh, sorry, but the bar to the commencement of a judicial action in paragraph 20 and the right to acceleration are contingent on the borrower being notified, not contingent on a letter arriving at a specific address. That's in paragraph 15, which, and so do you want to reserve time, by the way? I apologize. I was going to.
Yes, I would. And I would just, I can answer that briefly. The notice provision of paragraph 15 does have another other means entity. So if it's sent by first class mail, then it's deemed sent when, or it's deemed received rather when it's sent. If it's sent by other means, then it's deemed sent when it's delivered. And so there is a distinction there in paragraph 15. It's not just we have to send it and we can send it wherever we want and it's deemed received by the borrower. The borrower is deemed to have been given notice, because if it's sent by first class mail to the notice address, then the receipt is presumed by the sending. If it's delivered by any other means, then it's on the date on which it is delivered. That's the distinction. And I'll reserve the rest of my time, Judge.
All right, Mr. Siegel, you have 4 minutes.
Thank you.
And Ms. Holliday.
Thank you. May it please the court. Sarah Holliday on behalf of the appellee. This court can affirm the final judgment of the lower court on numerous grounds, including because there was substantial competent evidence to support that conditions precedent had been met, especially as pled or as argued in their affirmative defense. As to the contents of the letter, and as far as mailing goes, to the extent that is a portion of the conditions precedent, I agree with Judge Atkinson. That's a little bit unclear because it paragraph 15 is a presumption of receipt or delivery of notice. But to the extent that it is a condition precedent, that you still have to show that if you didn't substantially comply with it, that there is some prejudice. And this court has held that as recently as October of 2020 in the Koonsman case, that even if substantial compliance fails, there still has to be prejudice. And what the lower court found at page 426 of the record specifically found that there had been substantial evidence concerning the mailing process of the default letters, that they were sent to the property address and the PO box address. And then it went on to discuss the lack of prejudice, the fact that there had been a prior case, the fact that the defendant admitted that he had made no payments since 2008 or 2009.
You said yes. You did rely on that. So he admitted that he had made no payments. And let's just assume that there was, and you can confirm this, that there was evidence that he knew he was quote unquote in default. Because there have been, doesn't this notice require a little more? Does this notice require some explanation of how he can cure, the ability to cure? In other words, so just because at some previous point he knew he was in default, and why does that? How does that get past the condition precedent regarding the type of notice that's required for acceleration?
The answer to that would be because he knew he was previously in default, made no attempt to cure. He clearly had received the prior notice.
That seems like it goes maybe to prejudice, but like, well, he couldn't cure it. But my saying is like, does the notice require something more than, hey, you were supposed to pay all these payments and you didn't. Now you are in what is a technical term for us lawyers and bankers called default, and as defined in the document. Isn't there something more required for paragraph 22?
There are specific requirements as far as you have to inform them of the right to reinstate, that he has the right to cure within 30 days,
So how does his knowledge that he had been deemed in default before, and his knowledge that if I don't pay my payments, I'll be in default, how does that satisfy paragraph 22 requirement for notice? Just that alone, when paragraph 22 requires those rights you just started to enumerate.
Well, I would argue that because the notice was sent to the property address, which is listed in the mortgage, which is a notice address.
Which is a different argument, right? Your argument before was, hey, he hasn't paid his payments, he never tried. Mm-hmm. So you're going, now we've diverted to a different argument, which is he might have actually gotten this piece of paper that says you're in default, here's how you can reinstate, here's how you can cure, etc. So and you say, well, because it was sent to the property address, are you saying that's the burden shifts then? Or, wasn't there evidence that that there were renters there? I mean, wasn't that whole, go ahead.
Yeah, so the testimony at trial when he admitted his default was actually that he had lost his renters, and that's why he could not make any payments. So that goes to, again, as we were discussing earlier, the prejudice.
Necessarily living at the house.
Correct. But yes, but the fact that he had been consistently in the prior foreclosure action represented by the same counsel and knew he was in default, knew the process to cure because he'd received the prior letter. And I would argue this letter as well, although it was disputed what
the counsel kind of impugned that rationale by saying, well, you didn't introduce, well, maybe it wasn't counsel, I don't know, but you didn't introduce that letter. You just said, hey, he must have gotten a letter. He was sued for foreclosure before. Or am I now impugning your argument? I don't know.
No, I mean, the court essentially found that in reading the actual thing, it says, based on the previous case that began in 2009, dismissed in 2018, this case was filed in 2019, and the admissions of the defendant, and the court focused really on the prejudice aspect of this, which is that
I wanted to focus on what you just said, which is that not prejudice but as in that served as notice. The fact that this is a second go round means that he was effectively notified of what paragraph 22 requires a defendant to be notified of.
Correct. He was effectively notified because he knew he was in default. He knew that you could cure the default, prevent the foreclosure, and reinstate, and he didn't do it.
How do you know that?
Because
are you relying on the fact that a letter was that the notice letter was introduced at the previous, or I don't remember how far that got. I mean, there's no involuntary dismissal after the bank's presentation of evidence. Are you relying on the evidence adduced prior to involuntary dismissal, which included the letter and paragraph 22 letter?
Right. I don't think that we can, because the paragraph 22 letter, to your point, is not actually in the record of this case. I don't think we can rely upon that to say that a letter was sent, but the fact that there was a foreclosure and there are allegations in the foreclosure complaint itself that talk about the default, what's required to cure and no cure, and acceleration, all of that, plus he was defended for eight plus years, decade, in the prior case concerning what was and was not required, fully represented by counsel. He was on notice of what he needed to do to cure. And I would point out that what they argue on appeal is that it is the wrong address. What they argued what they pled in their specific denial to the conditions precedent, and then also in their fourth affirmative defense at pages 101 and then 103 to 104, was the substance of the letter. That actually didn't, and whether or not he had the substance of the letter and the benefit of the information from paragraph 22 was not really the issue at trial and isn't the issue on appeal. But the issue on appeal is whether or not, by virtue of sending it to what the appellant claims is the wrong address, we failed paragraph 22.
Could we write an opinion? Could we write an opinion affirming and saying that he waived the affirmative defense by not pleading its specificity?
Absolutely. Yes, absolutely.
That we could support that. Case law would support under these circumstances.
Yes, and we cited several cases in our brief that talk about that, including the Hawthorne excuse me, not Hawthorne, the Quinnan case out of this court, where it was a 559-715 affirmative defense case. And what the court said is, because conditions precedent must be pled with specificity and particularity, you have to say exactly what you contend was not done on the condition precedent, especially where, as in the case of 559-715, and in our case, where there's a paragraph 22 that has a whole bunch of different conditions for what the notice has to require, you have to be specific. And what this court found is that because the answer in the Quinnan case didn't allege how the bank failed to satisfy the statute's requirements, nor did their denial indicate what within the statute was supposed to occur, but did not, it wasn't specific enough. Here, I would say, in addition to the defense and the specific denial not being specific enough, is fairly boilerplate. They didn't plead anywhere in their affirmative defense or their specific denial, you sent it to the wrong address. That would have put the bank on notice of that particular defense to be argued at trial. I would also argue that this court could affirm under a Tipsy-Coachman doctrine, because you can look at the holistic record. And to Judge Labyrinth's point earlier, there is a affidavit of due diligence that lists the P.O. box as the mailing address for the property at issue here. It's listed on his driver's license, on professional licenses, and with U.S. Postal Office. And then also within the case, there was a document filed by one of Mr. Chesney's prior attorneys at record 431, where the attorney specifically lists this P.O. box as his mailing address. So under Karacha, probably saying that wrong, and the Hawthorne case out of the 4th DCA, where it talks about if you send it to a valid address, the fact that you didn't send it to the purported designated notice address, there's a lack of prejudice because you've actually received a benefit because it was actually going to a valid address. And you can show that through various means, including person was served there. They use it as
Ms. Holliday, I don't remember from reading the brief. Is there any dispute that the address was mailed to the property address? I'm sorry, that the notice was mailed to the property address and to the P.O. box?
No, it was pretty established that it was mailed. There wasn't really a lot of dispute about the mailing practices and that it was sent. It was just the argument that it was sent.
And did the bank introduce evidence? Typically, there's a record of the default notices going out to those addresses. Is that in the record?
Correct, Your Honor. Yes. And in fact, the trial court, in its specific findings of fact, it says the default letters in this case were properly authenticated as to the mailing procedure. They were sent to the property address and the P.O. box.
Okay. All right. Thank you. I'm sorry I had overlooked.
No worries. No worries.
Findings.
The other thing I would argue here, as far as another reason to affirm, is that the argument on appeal is that the notice was not sent to the mailing address as noted in the mortgage. And counsel has argued that that means that it was a designated mailing address under paragraph 15. What I wanted to note for the court is that under the Hawthorne case, interestingly, that case was about the bank sending the notice to the mailing address noted on the signature line of the mortgage in that case. But there was no evidence that that particular address was separately designated under paragraph 15 as is required. But what the court said there is that because it is a valid address, and it was shown to be a valid address because the guy was actually served there, there was no prejudice in that case, and that the mailing was complied with. Here, I would say, since there was no evidence by the borrower that the mailing address as noted on the signature line was actually a designated address and we were required to send notice there, sending notice to the property was sufficient under paragraph 15.
So yeah, I was actually going to touch on that, and there wasn't a whole lot made of it, but if we're going to get very technical about everything, it didn't say notice address, it said mailing address.
Correct.
I'm not sure how typical or atypical that is when it comes to a designation. Was that argued below? Or was that a product of my own mind?
That was not
argued.
argued.
It seems most of the arguments concede that by affixing the term mailing address above the address in question, that made it the notice address. Are you conceding that?
Well, I
Most
think
concede that
I'm not.
against it.
I think below what trial counsel for the bank argued was that because there was not, and she argued more specifically that it didn't appear elsewhere in the mortgage. I think she argued it wasn't on the first page as the
Right.
designated address. So I don't know that it really got into that hyper technical detail.
Well, there's also a portion that talks about the fact that if you want to change it, you have to change it pursuant to the procedures for change set forth by the bank, but there's no procedures for designating it.
Correct.
Am I
And
right?
and not actually in the mortgage, which I think is what Hawthorne was getting at out of the fourth DCA. I think that's what they were getting at, to say, just because it's listed as a mailing address on the mortgage doesn't mean that it's necessarily the designated notice address for purposes of paragraph 15. Now, in that case, sending it to that mailing address was sufficient because it was a valid address for the borrower and therefore no prejudice. But I think that that's instructive here, because if you look at substantial compliance with both the notice and what, deeming the notice we sent, if you can't show that there was some other designated notice address, sending it to the property was sufficient. And if there are no further questions, I will cede the rest of my time.
Thank you. Mr. Siegel.
Yes, Your Honor, to address a couple points. If the court looks at record page 46, the notice of action, it says current residence unknown, but whose last known address was 1018 Spanish Oaks Boulevard, Palm Harbor, Florida 34683. If the court looks at the record on page 49, the affidavit of the attorney for the plaintiff, paragraph 4 says the last known mailing address of the defendant is Chris Chesney, 1018 Spanish Oaks Boulevard, Palm Harbor, Florida 34863. So to say that there's nothing in the record that shows this was a mailing address, the plaintiff's own statement shows that.
Notice address.
Well, but okay, so the property address is defined as the address where the property is located. What other purpose would there be to establish a mailing address, especially when you take into account that mailing address was not written in by the borrower? This is a pre-printed form that the borrower is provided to sign. And so the bank drafts the form, puts a mailing address on there that is different than the property address. What other purpose but for notice purposes would it have?
That's interesting you bring up that point, because you emphasize the fact that the borrower didn't designate anything.
Well, no, the borrower did designate, and it's reflected by the fact that it's
You just
drafted
signed
into the
something that the
document.
bank wrote in mailing address, is what you're saying, right?
Right. And where does the bank get that information? Right. The bank doesn't magically appear into the bank's
But I'm saying if you
universe.
want, yeah.
The information has to come from the borrower. This is the property address. Here's where I want stuff mailed. Why do I want stuff mailed to an address that's different than the property address? Because I don't live there. Because I have an I-4 rider that allows me to rent the property. Because there's a clause in the I-4 rider that deletes the occupancy requirements of the mortgage that requires me to occupy the property. So that's why I have a mailing address, so that I can get mail relating to this mortgage at that other address, not at the property address, since I'm not going to be living there. Most mortgages don't have that. Most mortgages, the property address is the mailing address. Why? Because the borrowers are borrowing money to purchase a house they're living in. This case, it was clear that by the mortgage and by the I-4 rider, that's an investment property. It's something that the borrower is buying to rent out and make income from and pay the mortgage using those rents. When she talked about, she asked Mr. Chesney at trial, why'd you stop making the payments? He said, because the renter stopped paying me. That doesn't mean it stopped being rented. He might have to do an eviction. He might have to get new tenants. But the point is in 2014, when they claim the default date is, the parties are litigating the 09 case. In 2018.
I'm sorry, your time is short, but so I wanted you to touch on before your time ran out, but the point that the bank just argued, which is that even though, yes, the fact that he knew he was in default doesn't include everything that is in the paragraph 22 letter regarding the right to cure, et cetera. The fact that he was sued for foreclosure and in the foreclosure complaint or at some point along the way, he would have been apprised of his right to reinstate, et cetera. Why isn't that notice? If you, again, take my point for the sake of discussion, that the condition precedent is notice, not a letter going to a specific address.
Because at the time of the filing of the complaint, it's too late to reinstate. The letter gives you the right to cure the default and resume making payments. And it's important that they move the default date in the new case, because it's one thing to say, well, he knew he was in default. Yeah, he knew he was in default from 2008, 2009, whenever the default was alleged in the first case. But once that case is involuntarily dismissed with prejudice, they pick a new date. Is he supposed to guess what new date they're picking? Is he supposed to presume that that new date is correct? It was something else that was argued below, is whether or not that default date is even doable, because in 2014 the parties are still
But
litigating.
they're saying, what does any of that matter if he did know at one point that he was in default and could cure? What does that even matter if he never pays his payments?
Because he doesn't know what the correct amount to cure was in 2018 after the dismissal of the first case. He has no ability to discern what the bank would accept unless he receives a notice from them saying, here's what we're calling you in default in, here's what you need to pay us in order to reinstate this loan. He never gets the letter, so he can't take any action. Once the complaint is filed, the acceleration's occurred. The acceleration occurs upon the filing of the complaint. And so at that time, he can no longer take the action required by the letter to cure the default. And more importantly, the letter is not attached to the complaint, so that in the affirmative defense, when we say they have not given the notice, that presumes within it that either it was not given, period, or if it was given, it didn't get to him. In other words, it was sent to the wrong address. So to say that it's not specific enough, or that it doesn't specifically enough address what the condition precedent that was breached was, I think is nonsensical, because the affirmative defense.
Mr. Siegel, just to that point, and I'll let you go a little bit over since we're peppering you with questions at the end. Quinion includes a pretty basic pronouncement, which is in order to properly put a failure of condition precedent into play, you must not only plead the nature of the condition precedent that has not been complied with, but also the nature of the failure. And it's not a very high standard, but I mean, those are two separate things. You can't just say fail to comply with paragraph 22. You got to say what the failure was.
Right, and the
reason for that is because as Quinion and Asbury may point out, is that you, the party that are pleading the alleged noncompliance with condition precedent, are in the best position to put that to crystallize that issue.
And so in paragraph 8 of the amended answer, it states that plaintiff has not met all conditions precedent, that the lender has failed to give notice. 1, which meets the specific requirements of paragraph 22. The notice did not specifically inform the borrowers, 1, of the default, 2, of the action required to cure the default, 3, of a date not less than 30 days from the date of the notice is given to the borrowers by which the default.
That all sounds like about the contents.
Yeah.
Right, but it's also failed to give the notice. And then if you go down,
it doesn't say that though. The noncompliance that you allege relates entirely to content. I mean, this is the kind of, not that you were doing this intentionally, but the whole point of Quinion and Asbury is to prevent rope-a-dope non-condition, failure to comply with conditions precedent defenses from being litigated. It's to say, look, you didn't get it, right? Your client says, I never got this notice. You got to put that into the defense, and then you all can get discovery and you can flesh it out.
Or the plaintiff can voluntarily dismiss and start over again.
So further down in the denial paragraph, and I'll get to the affirmative defense also, but it says lender may not commence any judicial action until borrowers have, 1, been given such notice. The lack of notice prejudices the defendant in that the borrower were unable to timely cure the default at an affordable amount, which borrower had the ability to pay had they been properly and timely advised of the default. That's all in the specific denial. When we go to
we can it's in the record. We can read it and it says what it says, and if it meets the legal requirements, it does.
I just want to point out the 4th affirmative defense, which ties into the specific denial, says plaintiff has failed to comply with condition precedent to foreclosure, such as failing to send an acceleration letter and verification of the debt to the defendants. So that's a failure to send. To say that, we didn't send it to the right address, but we sent it, and you didn't say that specifically enough, how would we know what address you sent it to if you didn't send it to the right address?
Gotcha.
Because if we knew it existed, then you would have sent it to the right address. So I think it's specific enough.
You would say read those in tandem, and that gets you to where you need to go. So I think I understand your argument.
Yes, Your Honor.
Okay. All right.
So
Well,
we
thank you
would
very
ask
much,
the
Mr.
court-
Siegel.
Thank you.
Ms. Holliday, we'll give this deliberation as we bring in our last and final case of the docket today, which is Sloan versus SCI Funeral Services.